You're now live.
And about a minute until meeting time. As a matter of fact, it is 4:30 now. It's April 26th, and I will call this meeting of the Judiciary and Law Committee meeting to order. This is a standing committee of the Dunn County Board of Supervisors. I see that all 5 members of the committee are present, as well as Chairman Bartlett, so the roll call can reflect that. And I would entertain a motion to approve the minutes from the March 22nd meeting. Carl Vandemillen moves, Bob Bauer seconds. Any discussion, changes, corrections, additions to the minutes? Seeing none. All those in favor of the motion to approve the minutes, say aye.
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 Aye. Thank you. Any opposed? Motion carries. We don't have any public, so we'll go to item number 5, which are staff reports. And again, you should have those in your packet if you have any questions, or I will ask each of the department heads if they have anything to add. Starting with Marcy, anything to add to your report for the medical examiner?
Good evening. The only thing that I have to add, since the written report is, I am anticipating the possibility of a resignation of one of my longest time term employees. She's struggling with possibly having to resign, and it's not because she's unhappy with her job, it's personal reasons. So I may be down an extra person other than what was described in the report.
And it's, how difficult is it recruiting for those deputy positions?
It's extremely difficult, and even more difficult getting them trained up to the point where they can be on their own. We don't have a labor pool of any medical examiners, in the area, never have. We train them for this position. There's not schooling locally for medical examiners. So we basically take a retired firefighter or law enforcement and train them for this job, which can take 6 months to a year to get them where they can be really out working on their own without a second person alongside of them. So these, as I had reported, my deputy Serena and her husband have adopted a baby. They're still not back home with him, and she'll be off for most of the summer. And there might be some likely anticipation for a longer ask for a longer leave of absence because he's got some health problems. And now if this other deputy does resign, we're going to be sitting in a spot that I don't want to be in, because it really puts all of the load, most of the load, on myself and Chief Deputy Lynn Johnson, as we're the only 2 full-time people that are salaried, and all of my other employees have full-time jobs, and so they're only available when they're available. That is my communication.
Just had a deputy retire, you better go recruit him.
Yes.
Anybody have any questions for Marcy regarding the medical examiner's report? Thank you, Marcy.
You're welcome.
If you need to leave, don't hesitate to do what you need to do.
Thank you.
Next up is the Sheriff's Department and the jail. Kevin, do you have anything to add, or?
No, I don't think I do from my written report.
Any
It was my
questions
turkey
for the
season
sheriff?
last week and I didn't get a turkey, but other than that.
Questions for the sheriff? How about Brenda? I know you're on the line yet, right?
We had our jail inspection last week and it went very well. And we're still working on the nurse's office floor. But other than that, nothing to add.
they find any asbestos in that flooring?
No, they did not.
You're lucky.
Yes.
Questions for the sheriff or the jailer? Seeing none, we'll move right along to who's next. Did I hear somebody? Courts are next.
Yeah, good evening. The only thing I have to add to my written report is we had one additional jury trial since the date that I submitted it. And then I'm recruiting for a deputy jury bailiff position at this time as well, due to us getting a third judicial branch. But otherwise, nothing else to add to my written report unless there's questions.
Questions for Katie? I just was kind of curious as to the two new judges, the judges elect, who will begin their terms in August. I would guess that there's a pretty serious set of training that they go through, or not?
Well, actually, the state puts the training on, so they'll go to judicial college the last week in August for 1 week, but they actually start their term August 1st of 2021. So they're going to go on a mentoring program for 2 weeks. So our district court administrator, they will divvy up where they're going to train and mentor between other judges around our area. Most likely they'll be placed between St. Croix County and Eau Claire County judges. And then possibly a little bit, maybe Judge Smeltzer would be willing to assist, and Judge Peterson as well. So the training is probably not as much as what all of us anticipate it would be, but that week at the end of August, hopefully they'll learn a lot of things that they need to. They technically will go to Madison the last 3 days during the month of July and get some state training regarding human resources things and, information about their position. Judge Peterson and myself have a meeting with both of the judge elects tomorrow night too, just to go over transitioning cases and, what to expect from the county and what their role will be in Dunn County. So it's going to be an interesting change. I've never been in this position with a new judge. I've been just a deputy before. So it's exciting, but it'll be a challenge. I know one of the judges will have more conflict with other cases than the others. So I do anticipate that we might have quite a few cases reassigned to either the new branch 3 judge or possibly out of county as well, due to the conflict with some family and juvenile cases that she currently presides over.
That must be Judge Meyer. I know she shows up on our voucher list as a guardian ad litem pretty often.
Yes, she does. Yep, I do anticipate that will be a bigger conflict, but she'll get to learn some different areas of the law and might get more criminal cases than maybe what Judge Wagner will get right away in the beginning. So I'm working with a DCA right now to reallocate, and our chief judge of the 10th Judicial District is going to issue probably a written order as to what our plan is going to be. And then parties will be given the new judge and then have the opportunity to request a substitution of judge if they wish to do so. They cannot file those papers until after 8/1 of 2021. So come August, I think it's going to be pretty busy just with that new transition and getting new notices out. And I think defense counsel has a tendency to want to file a request for substitution on a new judge, just not knowing what their stance will be on certain aspects. So it's going to be interesting for the next few months.
Do they have to take a class in Latin?
And not to my knowledge. Hopefully they pass that in law school.
I would think they would. I know they're going to be really busy, but remind them that they can sit in on these meetings anytime they want to. It'd be nice for us to be introduced as well. So
That sounds good. I'll mention that to them tomorrow night, and then maybe next month we'll invite them out in for the Judiciary Law meetings.
not that they don't have enough to do already, but thank you, Katie. Anybody else questions for the courts? Seeing none, I think CJCC is next.
Good evening. Nothing further to add to my written report unless there's questions.
Questions for Sarah? I just had one, and that was about the Family Treatment Court Coordinator. Are you recruiting for that position now? What's the anticipated replacement for that?
So that position is contracted from DHS to house calls. So they have put in a offer to somebody in that position. There was a vacancy in the social work area that was out there. So we had a kind of a pool of candidates to consider, and really wanted somebody that had some experience. But Human Services went ahead and made that hire already.
Okay. Thank you. Anybody else? Anything for Sarah? All right, the DA's report is next. Andrea.
Hi, good evening. The only thing I have to add is we have actually started to use this iCloud-based storage for trying to see if it's going to be a feasible option for all the additional media that we have. Especially, I'm very concerned when body cameras are starting to be worn, the cost and time that my office would be spending copying and saving videos as well as media, and then a copy for our file, a copy for the defense. This is a program where law enforcement would upload it to this iCloud system. My office then would have access. We can view it and then send a link to the defense attorney. A number of, I think there's 13 counties in the state that are using it. So far, it's worked well. I was a little bit concerned about our internet speed, but so far it's working well. I haven't been able to talk to the police department or sheriff's office as to how it's working for them, but I'm hopeful that it will be a good option, just given all the data that we have. That being said, there will be certainly a cost associated with that, and so that's something we have to figure out next. And then the other thing I wanted to add is I did go to the legislative meeting and did speak briefly, just sort of in support of having pay progression for prosecutors. Now that we have 2 new positions, it's really important that we can retain experienced prosecutors. Frequently, we have people join for a couple of years and then leave for the private sector where they can earn substantially more.
Any other questions regarding the DA's office?
Hello.
Andrea, do we have any rough ideas on if you go to the cloud system for your record storage, that's going to mean basically a decrease in revenue in your office? Is that correct? Are we talking a couple of thousand, couple of million, couple of hundred, couple of what?
No, our entire, I think, budget for revenue is 5,000 for the year. It will increase some because we can't charge as much for paper. We still can charge for the amount of data, but I don't know how much data is going to be on these body cameras as well. So I'm not sure, but there may be a slight decrease, 1,000, 2,000 at most.
Okay. And we've been kind of expecting, well, when the body camera data starts being uploaded, that's going to be a significant increase in the amount of data that has to be handled too. So we'll do it. He's not registered to speak publicly, by the way. So
I'm sorry. Thank you.
That's all right. I don't get to see many kids anymore.
Yeah, I've got a lot here. A lot of energy.
Anything else for Andrew? Oh, one last thing, and that is be sure to congratulate Barb Landy on the well-deserved award. And thanks to you for being thoughtful enough to nominate her for that.
All right, thank you.
Okay. Child support. Josie?
Hello. I do have a few things since my report was submitted. The Wisconsin Child Support Enforcement Association has decided to hold its fall conference in person in La Crosse. That's October 20th through the 22nd. Child support staff have to be in person. The attorneys that could attend, they have an option to either be in person or participate remotely. And they're making that concession for them because it's important for them to get their CLE credits so they can continue to practice on our cases. So I'll be reserving probably 3 people to go to that in the fall. Morgan Wilbur was our unpaid intern that was being shared between child support and the clerk of courts, and she has finished up her time. And Katie shared with me last week that she got a job somewhere, so good for her. And then lastly, I have a staff who I feel needs some modifications to her workstation under ADA accommodations. So she submitted a doctor's note, and we have an ergonomic assessment scheduled with HR next week. So I'm not sure what those accommodations might be or how much it might cost. But I'm thinking we'll end up probably purchasing her a standing workstation. But I guess we'll find out about that hopefully next week. And that's all I have in addition to what was submitted.
Thank you, Josie. Did anybody have any questions? All right. Oh, don't see any. Thank you again, Josie.
Thank you.
And emergency communications, Melissa.
Hi there, just a couple of quick things. Since my report was submitted, I did want to let you know that the truck and trailer that we did sell that we actually owned, we sold that and gave the proceeds to Menominee Fire, and those 2 units sold for a total of $17,825. So I think that was well above what anyone had expected, and so that money was turned over to Menominee Fire for the hazmat team and kind of our portion of our agreement. So I did want to let you know that that was the total on that. I think I had a report a couple months ago, the program assistant has been vacant here in our office. Marie Marty transferred back to the sheriff's office first part of December. And I offered that to a gentleman last week, and he called today and turned it down. So I will move on to the second candidate. So that is still vacant at this time. And then we have a 26-year veteran retiring at the end of this week from the 911 center. So more vacancies. So that's all that's new since my report.
Questions for Melissa regarding emergency management? I did have one thing in your first paragraph. You talked about a grant proposal that was denied in an appeal. What was the basis for the denial and the appeal? Do you know?
I think that the basis that they used in every application that was submitted was basically the intent of the grant was for to house homeless that were COVID positive, not just homeless to keep them segregated so that we didn't have a COVID outbreak. So I think the intent of the grant was that if they were COVID positive, that this grant was going to pay for that. However, that was not really laid out in the instructions when we applied for the grant. But I am under the impression that every grant was denied based on that. Now, however, they have encouraged us to, do an appeal. And they are helping us with that. And we're, working with KT's office and also Chris Corpola through Human Services. So
good. All right. Questions for Melissa?
Mr. Chairman,
David, go ahead.
the truck and trailer that was just sold, the replacement for that, is that being replaced by Menominee Fire then? So
Yes.
Dunn County doesn't have to get involved with that at all anymore?
Correct.
Okay.
They purchased a new enclosed trailer, and they're going to use a truck that they already have in their fleet. So we will no longer own any of the hazmat equipment.
All right, thank you.
Yep.
As a follow-up to that, one of the reasons that they had to get rid of the truck is because they had a number of individuals who can't drive a stick shift. Do they? Well, never mind. Anything else for emergency communications, emergency management? Okay, thank you, Melissa. That brings us to Items 6 and 7, there are no agenda items for either of those. Item 8 on the agenda, we have 2 potential ordinance changes, new ordinances. One of them in terms of drug paraphernalia, the other one is sexting. And we should probably have a motion. I want to take them separately because they're very separate, different items. But I would entertain a motion on the use and possession of drug paraphernalia. And then we can have the sheriff speak to that, or court counsel Lang speak to that, and we can deal with that. Bob Bauer moves.
I second.
And Jim's on seconds. So we have a motion and a second to forward to the county board a recommendation for an ordinance creating an ordinance that would prohibit the use and possession of drug paraphernalia. Sheriff, anything you want to say about this?
Sure, I'll just add that this is it's a criminal violation right now, so this would give my officer some discretion on charging somebody with county ordinance and instead of charging them with a crime, and it would also give the DA's office some leverage on plea bargain opportunities. You know, there was a possession of marijuana ordinance, well, as long as I've been around for over 30 years, but there was never a ordinance on this paraphernalia. And so it really kind of ties the hands of the DA's office and the officers on the street without having an option to charge somebody with a forfeiture violation instead of charging them with a crime. And this really kind of just adopts the state statute in reference to drug paraphernalia. More money than would stay with the county instead of versus a crime.
Am I correct that if this is a county ordinance violation rather than a state crime charge, that the potential penalties would be substantially less? Is that correct?
That's correct. If they're charged with a crime, that they could end up with anywhere from a jail sentence to probation. This would be basically like a traffic forfeiture, where they pay the fine and they're done with it without consequences of possible jail or larger fines. The judge in a criminal case can assess whatever costs or fines and costs they so see fit, and this would be a simple fine, and the court costs go where they go, and the matter's over with. It doesn't go on somebody's criminal history then if they were charged with this, opposed to the state statute.
Thank you. Corporation Counsel, anything to add or any enlightenment you'd like to share with us? Can you tell us a little bit about where the ordinance came from? Well, not obviously, but probably there are similar ordinances in other counties.
Marshall Multoff sent a draft ordinance to me by email, and I did check around to see what other counties had. This one is more detailed than many other counties. It looks to me like it comes from either Door County or Brown County. I can't remember which. But the draft that he provided was almost verbatim what was in the other county's ordinance. I added a provision in there on 4F under the penalty that any drug paraphernalia would be seized and forfeited to the county. Just seemed to be useful to me. And it contains a forfeiture schedule for citation enforcement. And so I've been working on the citation ordinance, trying to add stuff into it. And I'll have to make sure that this is included in there so that citations, this ordinance specifically allows for citations, so it has detailed authority for citations. But I'd still like to add it into the citation ordinance. Otherwise, it's a pretty well detailed ordinance. The sheriff summarized it correctly. I've been in court when some of these, maybe not this one, but some state law violations that might, be on the lower end of the scale in terms of dangerousness and severity, end up getting pled down to county disorderly conduct because we don't have an analogous ordinance for the offense that was initially charged. So I think it'll be a good thing to add in for enforcement, and it'll allow the district attorney in her discretion to negotiate plea agreements with this ordinance as a place to land.
Thank you. Questions, comments? Bob?
Thank you, Mr. Chair. On general provisions under item C, can you explain that to me? After 18 years of age, only 18 years of age, or would they be 18 years of age or older?
That was a typo.
3 years younger than, I guess I don't understand.
That was a typo. In the original. And I have it corrected now. That should read or older. So it'll be a violation of this ordinance for any person 18 years of age or older to deliver drug paraphernalia to a person under 18 years of age if they're at least 13 years younger than the violator. So in other words, if an adult delivers to a teenager, well, any of the things listed under drug paraphernalia, pipes, some of this stuff, I don't even know what it is, to be honest with you. It's been a long time since college. Any of that stuff, pipes, I guess, really stands out. So if an adult were to give a 16-year-old, say, a pipe that was intended to be used for ingesting smoked marijuana or some other substance that then that would constitute a violation of this ordinance. It's meant to sort of cut off the friendly supply chain, would be my guess. And I don't know, maybe the sheriff has a follow-up comment on that, but that's what I would guess it's for, is just, so the older brother, older sister, or cool uncle or whatever can't provide this equipment for the use, so that with the intent that it be used for ingesting drugs.
And that it's just similar to not allowing adults to purchase alcohol for minors.
Right.
So.
Yeah, there are a couple of typos in here that I've corrected, and they'll be in the final version of this ordinance if the committee votes to move it up to the county board.
Other question, Mr. Rogers? Yes, sir.
So maybe I'm naive, but what's the difference between the pipes that people use for tobacco and the pipes that people use for marijuana or whatever? Is there a conflict there?
Not necessarily. We have to test the residue in the pipe that's used for smoking marijuana to confirm that there's THC present in that pipe. So a hookah, for example, looks like a bong, but hookah is used for smoking tobacco. And so we test the residue in that device to find out if there's THC present. So there could be absolutely nothing, no difference. And that's how they get away with selling these pipes in smoke shops because they're for tobacco use only. But that's the difference. We test the residue in them to make sure there's THC, and that's what that's what they're used for. The smell alone is usually a dead giveaway that it's marijuana residue versus tobacco residue, but we do test it.
So the actual use that is put to the device is going to have a bearing on it.
You see, Judge Peterson has joined us. Welcome. You care to weigh in on the ordinance regarding drug paraphernalia?
Well, I thought your meeting started at 5, and so I'm sorry.
Used to back in the olden
I was
days.
on time, but no, I don't think so. I think as a judicial branch, I should just leave that to, it's a policy decision, and kind of a legislative decision, and I probably should stay away from that. But, I would assume the ordinance would mirror the state statute and would require really the same proof, that it was intended to be used, primary intent to be used to ingest, inhale, or all the other things that are listed on the state statute. So, that would actually make it more practical if it were. But as far as actually having the ordinance and how it's enforced and so forth, I probably should avoid commenting on that.
Thank you. I'd have to leave it up to the judge and court counsel to answer the question about whether it's substantially the same as a state statute.
I believe that it is. I read the state statute. There are a lot of counties where the ordinance just says the Wisconsin statute section, whatever this is incorporated herein by reference. Any act prohibited by that section is prohibited by this ordinance. Any act required by that section is required by this ordinance. All of the penalties shall be the same. And then it'll set a forfeiture amount. There is something to be said for the kind of parsimony that comes with that type of ordinance. The problem is that people who read the ordinance or who ought to read the ordinance don't see the words that are in it because they're contained in some other place that they have to go find it. And so I kind of like an ordinance that has everything in it that's supposed to be, known by the people who are going to be following it or expected to follow it. But it is, I think it's nearly identical to what's contained in the state statute. It just makes it a county ordinance violation and therefore an alternative to the criminal charge. So this would, if it were charged under a county ordinance, it wouldn't be a criminal charge. If it were pled down to a county ordinance violation, it wouldn't be a criminal conviction.
Any other comment, question? Supervisor Vandermillen.
It just seems to me that things get really complicated if we have similar laws on both state and local level. And is it just totally up to the district attorney then to charge by one law or the other? And if so, doesn't it get kind of arbitrary?
I'd let the DA chime in on this one. Andrea?
Yeah, so I can just say that the Menominee Police Department has a possession of drug paraphernalia ordinance. I agree with the sheriff. It's just another tool that allows law enforcement to, instead of, referring charges for a criminal matter, can give them an ordinance, and it gives my office basically another tool to have. What we have been doing, since the county does not have a possession of drug paraphernalia ordinance, but the city does, is we amend it to either possession of THC ordinance or a disorderly conduct ordinance. And I don't think it's essentially fair for offenders to be having a THC or a disorderly conduct when really it should be a drug paraphernalia. So, I mean, I think it's just, it mirrors the state statute. It's just another tool for law enforcement as well as my office to use when we do charge these criminally and as part of a plea bargain, send it down to an ordinance, which will help them with not having a criminal conviction.
Thank you.
Yeah, thanks. That's helpful.
Chairman Bartlett.
Yeah, so I guess I was thinking that this would be mostly used in the DA's office as a tool for plea bargaining, but after listening to Andrea, that actually the deputy can make the decision to charge it one way or the other also?
Certainly, they have the discretion, similar to disorderly conduct. We can charge them if it rises to the level of a crime. Depends on their cooperation. There's a lot of things that officers can use for discretion. We currently have a possession of marijuana county ordinance, and we have a state law. And a lot of times, depending on the cooperation and things of the offender, the deputy may decide on the street to simply charge with a possession ordinance instead of charge them with a crime.
All right, thank you.
Anyone else? Any other comments, question, conversation? We have a motion to recommend the passage of this ordinance to the county board. Seeing no further comments, all those in favor of the motion say aye.
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 Any opposed? Motion carries. This will go to the county board in whatever month is coming up, May. God, I kind of lose track. Thank you, folks. On to the next item, which is another ordinance, similar rationale in creating this ordinance. It's an ordinance that would prohibit minor sexting. And I'm assuming that means sexting by minors, not just low-grade porn, right? I would entertain Carl, that wasn't funny. I would entertain a motion.
Same question.
I would entertain a motion to recommend forwarding to the county board with our recommendation. Is there such a motion?
Jim Zahn, so move.
Jim Zahns moves, Bob Bauer seconds. I have a motion and a second. I'm guessing, and the sheriff can elaborate, or Nick if he cares to, that the motivation here is similar to the motivation on the previous ordinance, in that it would allow for a little more discretion on a local level in terms of charging for this offense. Sheriff, if you care to, do you want to say anything about this sexting ordinance?
Sure. It's a tool. Menominee has an ordinance very similar to this. In fact, this may have come from Menominee's ordinance, and the school resource officers have found it very helpful to try and gain control over some of the nude pictures that are shared amongst high schoolers and things like that. Legally, child pornography, possession of child pornography is a felony. And it's tough to try and ring up a 16-year-old on a felony and push them to adult court for a nude picture that they shared with a boyfriend or something, or a boyfriend shares a nude picture of his girlfriend with. I mean, it can get a snowball into all kinds of things that could very easily turn into a felony charge. But I could throw this back to the DA again, and she's probably had more experience in dealing with some of these with Menominee I don't know if she's seen any of the ordinance citations come through her office or view any of these cases, but it's another tool, more of a slap on the wrist than look at convicting somebody of a very serious crime.
The only note that I have about it is, and this came in the draft that was sent to me, I highlighted it in yellow because it doesn't seem correct, and I didn't get any feedback from Marshall on it, but it's on the second page of the ordinance in section 3, and it just says a person in default is subject to imprisonment in the county jail until the forfeiture and costs are paid. I'm not an expert, but I don't think we can put minors and I think even adults in for that time frame. And I am trying to look up the city of Menominee's ordinance because I think this is similar. But I just wanted to make that note, so don't pass it until you get that resolved, I guess.
Nick, what would you recommend? Simply deleting that highlighted sentence?
That's definitely a possibility. The previous ordinance allows for a period of incarceration. Where is it now?
Yeah, not to exceed, I think it says somewhere in there.
Yeah, not to exceed. Yeah, that one is. So the previous ordinance is structured in tiers, seriousness of violations, and then they each have their own duration of county jail until fees and costs are paid. One is 30 days, one is 90 days, and one is 9 months. It's certainly not inappropriate to just toss that language out. It would take away one coercive mechanism for payment, but otherwise,
well, these aren't minors we're talking about here.
That's what
directed at minors.
Yeah, not everyone who violates this is
No,
going to.
That's true too.
A minor. Well, it is addressed specifically to minors, I guess. It seems to me there are other brother statutes that address this conduct when it's committed by an adult in federal and state law, I believe. Yeah, I don't think it would be a problem to take it out. I don't know what the sheriff thinks, if there's some substitute language.
I think they could be, those fines could be collected at the same path or options that we do on a traffic citation, and should mirror that probably.
Any person.
Supervisor Rogers, question?
Well, I would make a motion to remove that highlighted line from the resolution.
Supervisor Rogers made a motion to amend the language by deleting the highlighted sentence in section 3 regarding imprisonment. Do I have a second for the motion? I will second the motion. In the offensive sexting, paragraph 2, it says a minor commits the offense of sexting by knowingly. Is this ordinance directly, well, let me rephrase it. are there separate sexting ordinances or statutes that would cover adults doing these same things that do not, that this ordinance would not apply to? I said that kind of convoluted. Is this ordinance specifically for minors and no one else?
I believe that it is only for minors, the conduct of minors.
If that's the case, then I'm fully in favor of removing that paragraph, or excuse me, that phrase, that sentence that Supervisor Rogers moved to eliminate.
I'll just add that that's the intent of this ordinance, is to deal with minors. If adults share pornographic photos or video of minors, that's a much more serious offense and probably looking at prison time for that. So this is more of a slap on the wrist for minors to have a little bit of control or punishment for doing things like that.
And I agree. When I shared this with my wife this morning, we talked about our 13-year-old grandson, who is capable of, just as I was when I was 13, the most incredibly stupid things in the entire universe. And I think that this ordinance offers an opportunity to address those really stupid mistakes in a manner that's commensurate with the intent of the action in the first place. But in no way should a 13-year-old be treated the same way as a 33-year-old who's sharing pornography, child pornography. Supervisor Bauer.
Yeah, I agree with taking that sentence off there, but I think corporate counsel is looking at replacing it with something else. What would that be, maybe?
I don't have a recommendation. I don't do criminal law at all. And so it's been a long time since I've been involved. I understand the procedural mechanics of it very well, I think, but the penalty aspect, any limitations on incarceration, I don't know that off the top of my head. I think that, as the sheriff noted, this can be enforced in a way similar to other types of citations. I don't know that it's necessary to spell it out. It could be, but the ordinance doesn't become ineffective as a result of it. It still imposes a penalty for specific conduct. And I think it's worth noting, it doesn't tie the hands of the law enforcement or the district attorney in the case of, say, a terribly sophisticated 14-year-old with a media empire that is not contemplated by this ordinance. It could happen. There are state and federal laws that govern conduct of this nature. Sometimes it's lawful, sometimes it's not. The law would determine that. I think it's fine without any additional language, unless the sheriff has something to recommend specifically tonight. Otherwise, we could add it in at a later time if it's deemed necessary, if it begins to frustrate the purpose. If no one who's convicted of this ordinance or for violating this ordinance ever pays their forfeiture, and we're up to 600 of them or something like that, and we need something more to make it an effective tool, we could add language.
No, I think that the fines on these could be collected, and generally the suspension of a driver's license or things like that is what happens on a failure to pay another forfeiture violation. So, and we can't imprison juveniles
Right.
anyhow. So I agree with that sentence being removed.
I don't know where that, it was in the draft that I received and I questioned it, but I didn't get any.
Supervisor Rogers, did I see your hand up a minute ago?
Well, I guess I just wanted to touch on something we discussed a minute ago. Everything in this is pretty much about minors, was my understanding, and it only applied to minors. So I guess I was taken back when you started talking about adults.
Yeah, I just wanted to make sure that we were restricted to minors. And in terms of not paying their fines, again, if we wind up with a great big backlog of fines that are unpaid, maybe we can get them to work off those fines by washing supervisors' cars or something.
I will turn them over to the debt collection agency when they turn 18 years of age. We will collect on them at some point.
There you go. Other comments, questions, conversation regarding, oh, we have an amendment to vote on first, and that is to remove the language that's highlighted from section 3. Does everybody understand the motion? We're going to remove that imprisonment sentence. Any other conversation, questions, comments on that?
I will quickly note that the City of Menominee ordinance does not have that sentence in it.
Okay, thank you. We have a motion to amend the ordinance by removal of that language that's highlighted. All those in favor of the motion say aye.
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 Any opposed? Motion carries. Now we're back to the motion on the ordinance as a whole. Other comments, questions? Excuse me. If not, we have a motion to approve and recommend this ordinance to the county board. Seeing no further discussion, all those in favor of the motion say aye.
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 Any opposed? Motion carries. Thank you, folks. And thank you to Nick and District Attorney and the Sheriff for your insights into those. It takes us to item number 9 on the agenda. Are there any announcements? I don't have any. Item number 10, our next meeting, May 24th at 4:30. If you have not seen the message from County Manager Miller that came out this morning, I encourage you to look at that in the near future. Starting in May, all of the county board committees, boards, etc., will meet in person in room 60 of the government center that's in the basement. County board supervisors will be required to bring your laptops because the meetings will be a little bit of a hybrid meeting. Those of us who are in attendance in person will have a laptop so that people can see, people who are not at the meeting live can see us. And I want to encourage you to be kind of diligent about this. Over the past several months, I have attended a number of hybrid meetings where people were not very careful about bringing a laptop, and they get very difficult to follow. So this hybrid meeting is a little bit technologically challenging, but if the supervisors bring their laptops to the meetings and the staff does the same, I think we'll be in good shape. Speaking of the staff, makes sense to me that since you're all working in other buildings, that it would be entirely appropriate if you were to join the meeting via Zoom, if that's your choice. I mean, I'd love to see your smiling faces in person, no doubt about that. But the fact is that your work schedules are a little bit more prohibitive than those of us who are retired or, well, I guess Maybe I'm the only retired guy here. Huh? But anyway, use your judgment on that. It's going to be nice to have an opportunity to either be live or by Zoom. And that meeting will be on May 24th, 4:30. Again, room 60 in the Government Center building. Anything else for the good of the order? Yes, Supervisor Bauer.
Will the doors be open or do we have to have badges get in? Because I still have not received one of those. Was curious on that when I get.
That's actually a good question. I thought about that myself today. I'm assuming that by the end of the month, they will have had a chance to practice on some other committees and I'll have it ready for us. Chairman Bartlett, do you have any insights there?
CRT will be the first committee they try this on. I don't know. They still have the building locked up. So what we do with this, I don't know. We'll probably end up having everybody come in through the basement door. There's a keypad there, or maybe we'll have somebody at the door to let people in for the meeting. I don't know that. We'll let Mr. Miller work that out. This will just be for committee meetings, not the county board. County board will still be with Zoom for next month.
Anything else? Don't see anything. Thank you, folks. The meeting is adjourned. Take care. Stay safe. Stay healthy.